I'm Bob Friedman. I just have a few warnings before we get started. First off, that this is not a substitute for legal, tax, or investment advice. You need to consult with your own advisors as to what's best in your particular situation. Everyone's situation is different. Also, the laws are constantly changing and subject to different interpretations. They even vary from policies are even varying from one county to another, and they're certainly varied quite a bit from one state to another. Even though Medicaid is a federal program, each state has its own rules for eligibility. Also, I'm going to ask you to hold your questions to the end. We'll have time to answer questions at the end, or I can stay after beyond that, beyond 5 o'clock to answer questions. Just in fairness to everyone, usually people ask me questions about what I'm just about to cover. So what's the purpose here? It's to motivate you to do planning so you know what questions to ask your advisors. We're going to be covering a lot of information, but at least if you get some of the higher points of what's best in your particular situation. Like I said, each person's situation is different. I mean, just because your neighbor was able to preserve their assets before they went into a nursing home, your situation may be different. I mean, I'll tell you why. You have to a lot of this depends on, and I'll explain why. For instance, for saving your home, how long do you plan on living in your home before you sell it? What other assets do you own? That's what your advisors need to know to properly advise you. Do you have any disabled children? Do any of your children live with you? Do any of your siblings live with you? Do you have long-term care insurance? How is your health and your spouse's health? These are a lot of factors that will go into what type of planning is best in your particular situation. So how many people here want to go to a nursing home? So usually they don't get any response to that. So I mean, people often say, "I'll never let my mother go into a nursing home. I always take care of her." Well, there's a number of things that may prevent that. Very often, the path to a nursing home is someone breaks their hip, they go into rehab, and they won't release them back to the home. So one of my pet peeves is these home health care aides, okay? I mean, that's very expensive. One of my pet peeves about home health care agencies is they hire felons. In fact, there was someone here in the village of Akron a few years ago. The home health care aide already had charges against him, and he was hired, and he stole $90,000 in cash from this man's home in the village of Akron. They were able to prosecute him because he was stupid and put some of the toys he bought on Facebook that he bought with the money he stole. But it's very difficult. It was only because the sheriff's investigators are very good at investigating this. But you know, they give more jail time to someone that shoplifts a candy bar than they do for someone that steals $90,000. Very often, these white-collar crimes only get a year in jail. I had a client out in Rochester. The home health care aide took out a mortgage in her name and bought a house in her name and the elderly person's name for $300,000 and a BMW, and she was openly living in this house. She was eventually prosecuted, but the sheriffs weren't going to do much investigating about it. But this woman was living in a $300,000 home that was in the name of this elderly person who was living in an apartment. The woman closest relatives were in Ireland, so she thought she could get away with it. So she was a home care aide who referred to herself as, she claims she was a pastor also. And so what she did was it was independent living, but she was through an agency, but then she told the woman, I'm quitting the agency, you can just pay me directly. So that's just one of my pet peeves. So normally you have to get people it's going to cost you more, but you have to get word of mouth. But the problem with the home health care aides is it's difficult to get people to show up. That's the problem. So they're going to hire anyone. That's one of the problems you have with the commercial, but you may not have, if you get word of mouth. I mean, the proper way is to do it is through withholding and everything, but in all reality, you're going to have to end up paying cash usually to get good home health care aides. There's some very good ones out there, nurses and LPNs, but that's a situation, something you have to keep in mind. Anyway, so Medicaid eligibility, we're talking about if you do end up in a nursing home, like I said, usually it's, many of us have no choice. I mean, it's very emotionally and physically difficult for family members to take care of their parents on a long-term basis. So they may end up in a nursing home. And nursing homes have gotten worse, getting worse all the time. Even the 5-star nursing homes like McGuire are not very good. McGuire merged with Absolute, which Absolute is absolutely the worst, one of the worst, like the one down in East Aurora. So the problem is having enough staff. People lay around without being attended to. They all have the same problem, having enough staff. So a lot of nursing homes that I would have recommended a few years ago, I can't recommend anymore. There's very few that I would recommend. It's just a very difficult situation. They were hiring recently. I mean, they'll hire day nurses sometimes, come up from Jamestown actually. They're so short on nurses like for Elderwood, and they're paying them $150 an hour probably for the visiting nurses like they did in the hospitals, which they did during COVID. Anyway, so how are you going to pay if you do end up in long-term care? One overriding warning that I have is that if you don't have substantial assets in your name and you're in a hospital and you get discharged from a hospital, Medicare will cover part of it, but most rehab facilities will not take you unless you have substantial assets because they don't want to get stuck with you as a Medicaid patient. They're not supposed to discriminate against Medicaid patients, but they will. So if you no longer have that's what I warn people about putting their house, giving their house away or putting in a trust or life estate. If that's your only asset, you have to consider the fact that you may have a tough time getting into a good rehab facility. Like I said, the 5-star ones are not that great. The one-star ones are nightmares. There's a lot of those throughout Western New York. So it's something you got to keep in mind. One of the overriding things, if you're giving up all your assets, you have to give up control of your assets if you want to preserve whatever assets you want to preserve. So you have to keep that in mind. I warn people about putting their houses in, giving those away if they don't have any other assets. So if you have other assets, fine, they'll take you. Maybe if you have another $100,000 in assets, you get it. But to get into rehab, I mean, Medicare is going to cover they cover the first 20 days and then as a copay the next 80 days. But it may be difficult to get into a good rehab facility if you don't have other assets. So just so you have a background on that, I mean, to qualify for Medicaid, that's to pay for your long-term care in a nursing home, assisted living, or sometimes for home care aides. You're only allowed to keep $50 in income. There's a push to increase that. You can only keep $50 of income if you're single. We'll talk about if you're married later. For community to get aides in your home, you can keep $1,732 in income. Resources, and there's exceptions to the exceptions. That's why we're going to cover this. To qualify for Medicaid if you're single, you can only have $31,175 in resources. There's many exceptions to that. Your IRAs don't count. You could have $5 million in IRAs. You would still qualify. So what we often hear about the look-back period about qualifying for Medicaid. So when you do apply for Medicaid it could be for a skilled nursing facility, it could be for assisted living, or it could be for what they call community Medicaid to have aides come into your home, which is difficult. They will look at your bank records for the past 5 years. And if there's been any gifts, they may ask you for an explanation. So what does that mean? If you've given away assets, they'll go back 5 years. They'll look at your bank statements. If there's been withdrawals, usually of $1,000 or more, they ask you what happened to that. So basically, what that means is people say, well, they're going to take my house or whatever, is that you'll be disqualified from Medicaid for a certain period of time. You'll have to private pay. So if you've given away $128,000 over the past year, we'll talk about what gifts are, then they use a divisor of 12,842. So if you've given away $128,000 over the past 5 years, you will be disqualified from getting Medicaid benefits for approximately 10 months. So every $12,000 that you've given away in the past 5 months, either property or cash, you will be disqualified for 1 month of Medicaid. So for instance, if you've given away $128,000 in property or cash in the past 10 years, for instance, 5 years, you will have to private pay for 10 months. So there's different ways of getting around this. So what are gifts? Those are assets transferred for the purpose of qualifying for Medicaid. So basically, it's presumed that if you made gifts in the past 5 years, that you did to qualify for Medicaid. Now, that'd be money. If you sell your home to your children for $5, that's a gift. If you sell something for less than its full market value, then that's considered a gift. If your $300,000 house is transferred to your daughter for $5, you've given a gift of $295. So I encourage you to have regular medical checkups. I mean, if you've been healthy for the past 5 years, you can challenge that denial of Medicaid, that you've been in great health for the past 5 years and you didn't make these transfers to qualify for Medicaid. You're entitled to a fair hearing on that. So generally, transfers under $1,000, they may not question that. So the big misunderstanding is people say, well, I can give away $19,000 a year, right? It used to be $10,000. So that has nothing to do with Medicaid. So there's an estate and gift tax, and most people don't have to worry about it. There's an exemption of now a federal estate tax of $13,990,000 for U.S. per person and $7 million for New York. So back when I started practicing, when the exemptions were just a couple $100,000, all planning used to be around estate tax. Now, I don't know what's going to happen with the $13 million. That sunsets this year, so they will have to pass a new estate tax law. I assume it might be continued to a certain extent. So anyway, New York used to have a gift tax. They actually eliminated a tax. They eliminated a gift tax, but the U.S. tax system does have a gift tax. So during your lifetime or through your will, you can give away $13 million. So in addition to that, and this used to be a bigger consideration when the state tax was lower, you can also give away $19,000 to as many people as you want. In addition to that. So those exemptions don't have anything to do with Medicaid, okay? That just has to do with, so there's a lot of misunderstanding about that. But they also look at past patterns. If you normally give gifts for birthdays and weddings and so forth, you may not be penalized for that. So you should properly document all those gifts. So if a nursing home resident has a spouse back at home, is married and has a spouse back at home, there's protections for that spouse so that they can live. So if your husband or wife is in a nursing home, you're allowed still to have at least $157,000 in resources. Now this is in addition to the house. We'll talk about the house too. In addition to your house, you can still have $157,000 in resources. And whether it's in your name or your wife's name, your wife can transfer her assets into your name. And how is she going to do that? If she's incapacitated, we'll talk about that later. You're allowed to have at least $3,948 in your combined income, Social Security and everything else. Even if you have $1 million, your spouse can still qualify for Medicaid if you file a spousal refusal. They refuse to support your wife would still qualify for Medicaid. You can sign a spousal refusal. The county attorney can come and sue you to recoup the Medicaid, but that would be at the Medicaid rate, which is about $250 a day versus what the private pay rate is. How much is a nursing home a day now? Does anyone know?
400.
It's anywhere from $500 to $600 a day. So it's going up to about $19,000 a month. So there's various protections so that the well spouse at home can live. So another thing you may want to do is to update your will. If you're usually wills leave everything to your spouse and vice versa. So if your spouse is a resident in a nursing home, you will want to change your will. You don't want to leave everything to him or her because you may pass away. We can't predict. You may pass away before your spouse does in a nursing home, and you don't want all your money going to your spouse or be eaten up by the nursing home. So you would disinherit your spouse in your will. So that's the only reason. So you can't disinherit your spouse unless they've signed, like an antenuptial agreement, or unless they've abandoned you. So they have what's known as a right of election. If your husband or wife disinherit you, you can file a right of election of 1/3 of the estate. So the reason I mention that here is that if you disinherit your spouse, the county attorney may file a right of election against your. So if you pass away, you're living at home, your husband or wife passes away, and you've disinherited him or her, the county may file a right of election, but they only get 1/3 of your estate for your spouse that will go to the nursing home. I do an entire seminar on avoiding probate. I'll be doing it here in June, I believe, and also at the Amherst Senior Center in May, or next month, and the Amherst Senior Center next month. It's a question we get every day, what is probate? So this is something you all plan out with your advisors. So something we have to explain to people is there's many assets that don't pass through your will. So regardless of what your will says, there's assets that pass. So probate's the process. A question we get every day. So you drop a will appointing someone as your executor. That will itself does not give them authority. So your executor can't take the will to the bank and say, turn the bank over to me as executor. There's this whole process of probate, which means proving that the will is actually valid and all necessary people have been notified. Because there's people, you may disinherit, you can disinherit your kids in your will, but they still have a right to come forward into court, and they have a right to contest the will. They may not have any grounds to contest the will, but they have to be all this process. So you can disinherit your kids in your will. Like I said, you can't disinherit your spouse. Your spouse has a right of election. But this whole process of probate is that if you do disinherit your kids, they, just as one example, they have a right to come to court and contest the will, have a right to contest the will. They may not have grounds. That's something we go into. But there's some people, very often, people don't have a tough time understanding that, but your relatives may not ever have to go to court to have an executor appointed if you have non-probate assets, like life insurance. If you're a beneficiary in life insurance, you ask for a claim form, and with a death certificate, you get that. If there's beneficiaries so make sure your beneficiaries are updated. So sometimes someone may have gotten a life insurance policy back in the 50s, they named their mother as beneficiary and she's long gone, they never updated their beneficiaries. That becomes a probate estate if you don't have beneficiaries. Your IRAs, some people don't have IRA beneficiaries, but you should. That's a non-probate asset. And that's also not considered a resource when you apply for Medicaid. Like I said, IRAs and 401ks. So usually you want your beneficiaries to be able to roll over their IRAs into your beneficiary's name so they can delay paying the tax. Because if it's payable to your estate, then there'll be income tax due. Because that's IRAs, there's been people don't pay income tax on the IRA money. If you have annuities, those have beneficiaries, those could be non-probate. There's a lot of different forms of bank accounts, payable on death or joint ownership of bank accounts. Those don't go through probate. You can transfer one vehicle up to $25,000 for the DMV using an affidavit. That you don't have to go to court for that. There's living trusts, we'll talk about that. Your investment accounts for about the past 20 years, you can have those payable on death, and there's pros and cons to doing that, about how much control you want to have over those assets beyond your lifetime. We'll talk about different forms of real estate. So basically, real estate that's in a trust. We'll talk about life estates. That doesn't go through probate. If you have a joint ownership with rights of survivorship on a real estate, that doesn't go through probate. Really the only thing, and so usually widowers will come and they say that their spouse died and they have to transfer the house. Well, they don't have to transfer the house. It automatically transfers. If you bought your house while you were married and you were still married when your spouse died, the house automatically goes to you without probate. But there's occasionally we have clients that never put the house in their wife's name, and so the husband dies, the wife has to go through this whole probate process because they didn't do the simple thing of adding the wife to the deed. So that could be a probate. You have to go through probate with that. So these are things you talk about with your with your legal advisors about what's best to. There's pros and cons to avoiding probate. So, you avoid probate. Assets could go to young people that may not be able to manage it. So you may want to provide management through some living trusts. But anyway. That's something to consider in your will. Okay, so if there's one thing that you learned today, and that is, if there's one thing, the most important thing you learned today is you need to have a power of attorney. Everyone needs to have a power of attorney, and you have to have gifting powers in it. Because we'll talk about at the end, even if you never do any planning, there is, and I won't want to get great details about that, but if you've never done any planning and you end up in a nursing home, half your assets can be preserved. It has nothing to do with a 5-year look-back period if you have the proper power of attorney with gifting powers. So when I started practicing law, powers of attorney used to be 1 page. Now they're about 8 pages, but there's good reasons for that. There's been a lot of abuses by powers of attorney, but a power of attorney basically, it can go into effect immediately when you sign it and your agent signed it, or you can have it go into effect when you become incapacitated. Some people are paranoid. They don't want their agents to have authority right now. I don't really recommend a spring power of attorney. It does not go into effect until a doctor certifies that you are incapacitated. So normally, most of the powers we do go into effect right away, and they're only valid during your lifetime. Another big misconception is people go to the bank with a power of attorney after someone's deceased. It's no longer valid. So a power of attorney, you can give someone control over, be able to sign on your behalf for all financial matters except healthcare matters. You'll need a healthcare proxy for that. So there was a newer form that went into effect in June of 21, but the old forms are still available. But usually the old forms would limit the really old forms from 20, 30 years ago would limit gifts to only $10,000, which used to be, again, that used to be the gift tax exemption for making gifts. And that does you no good at all. So if you have an existing power of attorney, it may or may not be good. You should have your advisors look at it. But with a proper power of attorney, you'll be able to make some of these transfers that we're going to talk about, that you can make your real estate exempt and transfer your assets. So if you don't have a power of attorney, sometimes we have to do guardianship proceedings just for the purposes of making gifts, which we'll talk about. But so guardianships are for incapacitated people. They used to be called conservatorships. It's a court proceeding in Supreme Court in which someone needs someone to look after them, either for health care decisions, where they're going to live, or for financial decisions. So if you don't have the proper power of attorney, a guardianship may be necessary just to make those gifts, which can be, it could take weeks or it could take months to get a guardian appointed. And during this period of time, you may not be being able to protect your assets and being able to make gifts while you're in a nursing home. So that's the key things about powers of attorney. They're only valid during your lifetime. They'll still valid throughout your lifetime unless you revoke them or a court revokes them or you prepare a new power of attorney. How many people here have powers of attorney? Okay, that's good. Anyone have long-term care insurance? Okay, so long-term care insurance, that's another way of paying for nursing home care. There's traditional plans, there's hybrid plans. I'm not the expert on long-term care insurance, so I can refer you to someone that does do that. It would provide coverage if you're in a nursing home, if you're in assisted living or at home for home care. So there's the New York Partnership Plans. They provide coverage for 3 years, and then after the term is up on the New York Partnership Plans, you qualify for Medicaid regardless of how much you have in assets. Has anyone transferred their homes using a life estate deed to their children? Has anyone had living trusts? There's various options with preserving your house. I mean, for many of our clients, that's their major asset. They want to protect their home. As I said before, it could impede you from getting rehab services if you don't have any other assets. So there's a number of options, and I have an additional handout on that also, about the different options on protecting your home. So one option is to transfer your home to your children and keep life use. So it's a deed, you transfer it to your home, you keep life use. That protects it if you have to go into a nursing home, as long as you don't need to apply for 5 years. That does avoid probate. That's a non-probate asset, so it'll automatically go to your children, whoever's listed on there, upon your death. You also have the advantage of it's called a stepped-up cost basis. So even though you only paid $47,000 for your house in 1980, and it's worth $300,000 when you pass away, your children won't pay capital gains tax on it. They get what's called a stepped-up cost basis, the same as if you leave your house to your children or stocks to your children in your will. There's some disadvantages to that. One of those, the life estate deed ones, if you sell your home, then you're going to have to start all over again with a 5-year look-back period. So we'll talk about a trust that avoids that. If your children file bankruptcy, probably most of the value of your house would have to go to the bankruptcy trustee. They're on the deed, what's called a remainder interest. You have life use, which means you have the right to live there. You're still entitled to property tax exemptions. You have to reapply by March 1st, the March 1st following the date that you did the transfer. You'll lose out on your capital gains exclusion if you do sell the house during your lifetime. Your kids get the stepped up cost basis, but you don't get the capital gains exemption unless the house is transferred back to you before the closing, because you don't have full ownership of the house, you only have life use. So you do lose that. So as far as, and if your children are sued, there would be judgment liens against the house. Judgment liens are general liens that attach to any real estate that the person owns in that county. So sometimes what we did was we put the house in one child's name, and they sign an affidavit. They'll share the assets with the other children when the house is sold. So you put the house in the name of the child least likely to go bankrupt. But there are some other alternatives to that. This is something different. Numbers don't generally work out, but you sell your house and then you buy a house with your children or give them money to put an apartment or additional in-law apartment on their house, and the money can be protected that way. That's rarely used. Okay, so your primary residence is protected. There's a $1 million equity exemption, so what you have up to the value of your house less what the mortgage is, that's exempt, not considered as a resource. If your spouse is living there, or if you have children who are living there. If you're single, the exemption is only good for after 6 months. Your house would no longer be exempt as far as qualifying for Medicaid, because it's presumed you're not going to be moving back. So your spouse would be able to, in addition to the $157,000, your house can keep. The house would not be considered in you qualifying for Medicaid. Or if you have minor disabled or blind children in the residence, that would be exempt. So there's some other protections for the house. Like I said, it depends on what your particular situation is. If you have a brother or sister that's been residing with you for the past year, you can transfer the house to them, and there's no penalty for that. So how is that going to be done? If you're in a nursing home, you're not able to sign a deed, well, that's where the power of attorney comes in handy if it's got gifting powers. You could have the house transferred to your brother or your sister even though they're not on the deed. Caregiver child residing for the past 2 years. Usually the caregiver child's been residing for the past 50 years. But if you have if you have a child that's been living with you for the 2 years before you go into a nursing home, the house can be transferred to them, and there's no penalty for that. So that's whatever your particular situation is. They don't actually have to be your caregiver if that's been their primary residence for the past 2 years at least. So living trusts, Susie Orman may say everyone needs to have a living trust, but that depends on your particular situation, and that's the analysis we go through as to whether you should put your house in a life estate deed or a living trust. And I don't have this on here. People are asking about transfer on death deeds. So knowing what you know here, transfer on death deeds were authorized this past June. So transfer on death deeds don't protect your house at all for nursing home care. Transfer on death deeds, they can be revoked anytime. They don't go into effect until you pass away. So everything is still the same. It's similar to a will. Upon your death, the house would be transferred. But unlike a life estate deed, it doesn't protect your house from nursing home eligibility. So it's rather rare that they be used. If someone's not concerned about protecting their house, but they don't want their house to go through the whole probate process, they can do a transfer on death deed. We file that now. You can revoke that at any time. The person you transfer to has no rights to the house at all until you pass away. So living trusts can be revocable or irrevocable. Both of them avoid probate, but it has to be irrevocable to protect you from nursing home care. So irrevocable trust, we prepare this trust agreement. You can't be in charge of the trust. It would have to be your children or someone else. You have to give up control of the house. The trust agreement says you can live in the house, so that you'll still be entitled to your property tax exemptions. So I have it on the handout here too, the one. It avoids probate. The advantage over a life estate deed is if your kids go bankrupt or sued, it doesn't affect the house. They're just down as trustees, not personally. Really, the only disadvantage of that to the irrevocable trust is they don't get the stepped-up cost basis. So when the house is eventually sold, when you're gone, they will have to pay capital gains on the tax. So the advantages are that if you decide, you're sick of the 5-month winters here, and you want to move south, that your trustees would sell the house. The money would stay in the trust, and they could use that money to either invest it or buy you a house somewhere else. So you don't have to start all over again with a 5-year look-back period. And as I said, you can put other assets in the name of the trust. You can do that on your own. You can put investment accounts in there, depending on what your situation is, or bank accounts to preserve those if you go into a nursing home. So those are your main alternatives. Would be a life estate deed or an irrevocable trust if you want to protect your house if you go into a nursing home. You can also set aside money in a prepaid funeral account. That's not considered an asset. You would set it up with a funeral director. They set the money aside in a trust. For the most part, those are protected, except there was an incident here. There's an incident here with funeral directors in Akron and in Batavia who misappropriated the money in prepaid funeral accounts. But for the most part, with a reputable funeral director, that money is protected. That money that you set aside is not considered a resource in determining whether you qualify for Medicaid. Your IRAs and 401ks, those are not considered resource. They're not considered the $30,000 in qualifying for Medicaid as a resource. You can check with your advisors about qualified longevity annuity contracts. Those could be used to reduce the distributions that are required from your IRAs. So your IRA itself, on the resource side, is not considered in qualifying for you for Medicaid, but distributions from your IRAs would have to be used for nursing home care, because you can only keep $50 if you're single a month in income. So that's on the income side. But as far as qualifying for Medicaid, what's in your IRAs or 401ks would not be considered as far as qualifying you for Medicaid. Caregiver agreement. So your son or daughter has been helping you as a caregiver and managing your bills and so forth. If you pay them now for their past services, would that be considered a gift? You give them, if you transfer $50,000 to them now, would that be considered a gift? If they're your caregiver? Well, actually it will. To do that, social services require caregiver agreements. and you can pay them in advance for their services, but they do require really strictly worded caregiver agreements of what their services they're going to be performing for you, what the hourly rate is, and so forth. You can pay them in advance for their services. However, it's not a gift, so they will have to report it as income. Gifts aren't going to be taxable to your recipients of the gifts, but you will be penalized by Medicaid. But if you're paying them as caregivers to get around being disqualified from Medicaid, you have to have a proper caregiver agreement. Transfers to disabled children or other people, you can make unlimited gifts, either during your lifetime or in your will to disabled children, and it can be set up in special trust for them, and there's no penalty for that. So, and if disabled children inherit anything from you, that's not subject to Medicaid recovery, because Medicaid may file liens against estates of people that have been receiving Medicaid during their lifetime, and there's exemptions for disabled people. You can spend down your assets. One way you can give away things during your lifetime. That avoids probate. They don't consider the value of your automobile when you apply for Medicaid. You can pay off debts, do home improvements. So, we talked before about having the proper powers of attorney. So, try to explain this as simply as possible. But basically, if you've never done any planning and you're up in a nursing home, if you've had the proper power of attorney, if you have a guardian appointed for you, it has nothing to do with a 5-year look-back period. And that's why I say it's so important to have a proper power of attorney. If you've never done any planning, many people aren't aware of this, but if you end up in a nursing home, you can essentially gift half your assets. It's called emergency Medicaid planning with a promissory note. It's a very complicated calculation. You have to have an attorney do that for you. But basically, the steps is that you give all your assets to your children, and they promise to repay it. They sign a promissory note saying we're going to repay it, and they're going to repay it at what the monthly nursing home charge is. So if you have $300,000 in assets, you give the $300,000 to your children. They promise to repay $150,000, and if nursing home care is $15,000 a month, they're going to repay it half that for 10 months, $150,000, and you will qualify for Medicaid if it's done properly. After that 10 months, you will qualify for Medicaid if it's properly done. So that's why that's one of the alternatives to people that it's too late to make gifts because they may need nursing home care within the next 5 years. That is an alternative method of make people aware of that there still make gifts if it's too late, if you're not going to make it through if you don't think you're going to make it through 5 years of not needing Medicaid, that's still that alternative. So that's why I say we go through the so that's like the analysis we go through when people want to preserve their house. Whether they want to do a life estate deed, depending on what the family situation is. Like I said, the transfer on death deed is not going to preserve the house, so it'd be a life estate deed or putting their house in with an irrevocable trust. We do a trust agreement. So either way, you're going to be deeding your house. You either deed your house to your children with a life estate deed, or you create the trust agreement, and you deed your house. You sign your deed over to your children as trustees. So it's not in their names as individuals. If they get divorced, if they pass away, if they're sued, if they go bankrupt, it doesn't affect the house at all. So we look at these pros and cons. The tax, I touched on the tax consequences. There's not going to be any gift tax or estate tax consequences, but these are the analysis that you need to go over with your advisors as to what the income tax consequences are going to be, and the Medicaid consequences on making these gifts to your children. So, how many people here have health care proxies? Okay. So, health care proxies are another way of relieving your family from burdens and financial burdens also. So, basically, you have a constitutional right to refuse medical treatment. You have that right. You can refuse medical treatment, but you can't do that if you're incapacitated, right? How is anyone going to know your intention? So you sign a healthcare proxy appointing someone as your healthcare agent, but you also have to have a living will, not a living will, but a living trust. Living will is your specific direction. So your healthcare proxy cannot order discontinuance of tube feeding or artificial hydration unless you have that in your living will. We do a combined healthcare proxy living will. For instance, discontinue tube feeding. So another thing about the healthcare proxy living will, it's only good in nursing home and hospital settings. Does anyone have a MOLST? Does anyone know what a MOLST is? Medical order for life-sustaining treatment. So if you want people that want to go home for hospice care, they want to die at home, the healthcare proxies, living wills are not authorized in those situations. You have to sign, those are the pink forms. Your doctor or physician's assistant would do the pink form. It's a MOLST if you don't want to be revived, because otherwise EMTs may have to revive you when they come to your house. If you don't want your heart revived or your breathing, then you could sign a MOLST and they put that on your refrigerator. And so the EMTs will not revive you if you don't want to be revived. People want to be allowed to die, not have their breathing or their heartbeat revived. They want to be revived. So they do a MOLST, you do that. And you can go into a lot more details with your MOLST about what you do or do not want for your health care. So those are advanced directives. The MOLST completed by your doctor, or DNRs are completed by your doctor. If you don't want to be resuscitated for particular, you want your heart or breathing revived in a specific surgery, your living will, and a health care proxy. So those are all advanced directives, DNR and a MOLST. I'll take your.
Is it MOLST?
Yeah, medical order for life-sustaining treatment. You can ask your doctor about that. Medical order for life-sustaining treatment. Yes, there's the MOLST completed by DNRs are completed by a doctor, and that you do a health care proxy and a living will. We do a combined document. Sometimes it's done separately. And then you have your HIPAA authorization. We put those on the healthcare proxies too, because actually you have to have a specific HIPAA authorization. Those authorizations you sign with your doctors about access to your medical records. There's a HIPAA authorization on your powers of attorney also, because your powers of attorney may have to talk to your doctors about billing questions. So they have to have a HIPAA authorization even to talk to which is on the power of attorney, even to talk, unless you've designated it with your doctor. But even to talk to your doctor, if you want your agents to be able to talk to your doctors about your billing, they have to have a HIPAA authorization like the ones you sign with each of your doctors. So we've covered a lot of ground today. I have additional information on our website. There'll be a video of this presentation on our website. But if you have any questions, we've covered a lot of material today. Hopefully you absorbed some of it. As I said again, the big points are to have a power of attorney, and to consider what's going to happen about if you don't have enough assets to get into to be accepted by a good rehab facility. But generally we have to meet with people a couple of times for them to absorb all this information. So we give the people their different options of what they can do to plan things out, and then people need to think it over. It takes a while to absorb all this, but we're trying to cover as much as we can. Like I said, I'll give there's different pros and cons to avoiding probate. Cover that in the probate seminar. There's a lot to be considered too, whether or not you want to dispose of your assets through your will. Living trust can be a substitute for your will, where your assets can be used to a certain extent to your benefit during your lifetime, and it can provide management of your assets beyond your lifetime if you have disabled or young beneficiaries that need to have their assets managed. So either in your will, very often you can provide in your will. Most of our wills, if you have children or grandchildren that are maybe under 21, you can provide that their assets be managed for them by a trustee. Either you can set this up in your will upon your death, or you can set up during your lifetime as part of your living trust to have management of the assets. You can set up special trusts for disabled children or grandchildren so they don't lose their Medicaid or SSI, their Medicaid health insurance or SSI. So that's why I say it's all what your particular situation is, about who's in your household. If you have children in your household, you may not, if you have caregivers in your household, you may not have to transfer your house now. It could be transferred later on when you're in a nursing home to your caregiver children, and there'd be no penalty for that. So in some cases you may or may not want to, because everyone's situation is different. You may not want to transfer your house now if one of your children is still going to be living with you when you enter a nursing home.